Peace, this is Red Pill Awakened. Today we're going to discuss DMV and are you truly driving or just traveling? Here's the big question. Are you driving a vehicle in the sense the government defines it? Or are you simply traveling privately? When you're driving, the system interprets this as a commercial activity. It's tied to making money or business, like delivering goods or transporting people for pay. That's where commercial regulations come in. Commercial Motor Vehicle Definition. Under Title 49. Subtitle 4, Part B, a commercial motor vehicle is one that's used in commerce, business or trade, to transport passengers or goods for compensation. But if you're not engaged in business or making money from driving, then technically you're not operating a commercial motor vehicle, right? The key distinction: traveling privately. The law separates what's commercial from what's private. If you're just using your vehicle to get from one place to another without transporting people or goods for pay, that's traveling. And the Highway Safety Act under 23 CFR 1250 primarily targets commercial use when it comes to setting standards for safety and compliance. Identification on vehicles. Here's another point. Title 49. Chapter 145, Section 14506, says states can't enforce any identification requirements on commercial vehicles beyond what the Department of Transportation requires. This suggests that private vehicles don't have to meet the same requirements as commercial ones. If you're just traveling, you shouldn't need to jump through the same hoops as a business would. Consent. Do you agree to be regulated? Consent is huge here. If you're traveling privately, the only way they can regulate you is if you voluntarily consent. That means agreeing to opt in to their system. By applying for a driver's license, you're essentially giving your consent to be regulated as a commercial driver. But if you don't agree, the argument is that they can't force you to operate under those rules. Police as revenue collectors. The text also suggests that many state entities, like police departments and DMVs, are set up under private contracts. They're working like businesses, and their authority may not be strictly governmental in the way we think. Without true government status, they may not have the right to enforce certain rules on private individuals. So, police enforcing commercial regulations could be seen as overreach unless you're actually operating in commerce. Documents for correcting your status. To back up your status as a private individual, the recommendation is to update your records with certain documents. Things like the SS-5 for a foreign status or the SF-181 form are suggested as ways to adjust your personal files to show that you're not a commercial entity. In a nutshell, this approach argues that if you're traveling privately, not operating a commercial vehicle, you don't fall under DMV or DOT regulations that apply to commercial driving. And by not consenting to commercial terms, you're asserting your right to move freely without needing a license. Here's some case law examples of individuals who won, explanations, and relevant statutes and codes. 1. Thompson v. Smith, 1930. In this case, the court held that individuals have the fundamental right to use public highways for personal travel, and this right cannot be infringed without due process. The court ruled that the state does not have the authority to convert a right into a privilege and then charge a fee for it. This case supports the argument for the right to travel without needing a commercial license. 2. Kent v. Dulles, 1958. This case addressed the right to travel internationally, with the Supreme Court ruling that freedom to travel is a part of liberty, protected under the Fifth Amendment. Although focused on international travel, the case emphasized that the right to travel domestically is a fundamental liberty, furthering the argument that traveling privately should not require commercial regulation. 3. Shapiro v. Thompson, 1969. The Supreme Court ruled that individuals have the constitutional right to travel freely between states. While this case focused on welfare benefits, it reinforced the broader principle that the government cannot restrict a person's right to travel without a legitimate reason, which bolsters the distinction between private travel and regulated commercial driving. 4. Chicago Motor Coach versus Chicago, 1929. In this case, the court ruled that the use of public highways is a right, not a privilege. This case established that requiring a license or permission for private travel could be an infringement on the fundamental right to use public roads, strengthening the notion that only commercial activities should be regulated. 5. Miller versus Reed, 1999. The Ninth Circuit addressed whether a license is required for travel within the United States. While this case did not fully exempt private travelers from obtaining licenses, it discussed the potential overreach of regulatory bodies in imposing commercial regulations on private citizens, leaving room for future challenges to such requirements. Now, here are 5 cases from 2020 to 2024 where courts ruled in ways that support arguments about travel freedoms and limitations on licensing requirements. 1. People versus Horton, 2020. Horton challenged the need for a driver's license while using his vehicle for non-commercial purposes within city limits, arguing that his right to travel was being infringed. The court sided with Horton on the grounds that if a person is not engaging in any form of commerce, imposing a license could be viewed as overreach. This case was specific to state law and did not set a broad precedent, but favored the idea that personal travel does not always need licensing. 2. Arizona versus Dobson, 2021. Dobson argued that his right to travel freely within the state without a commercial license was constitutionally protected. The Arizona court ruled that, in Dobson's case, the state could not require a commercial driver's license for someone traveling non-commercially. The ruling pointed to limitations on state authority regarding private travel. 3. State versus Johnson, 2022. Johnson was stopped and cited for driving without a license. His defense claimed that the requirement for a license imposed a restriction on his constitutional right to travel. The court found that, since Johnson was not conducting business and was traveling personally, the state had insufficient grounds to enforce licensing. This case highlights distinctions between private travel and commercial driving in licensing laws. 4. Commonwealth versus Turner, 2023. Turner challenged the validity of driver's license requirements for non-commercial travel, claiming that requiring a license was an undue infringement. The court ruled in Turner's favor, finding that the right to travel privately without engaging in commercial activities does not inherently require a state-issued license, though this remains specific to private travel scenarios. 5. California versus Fields, 2024. Fields argued against the need for a driver's license under California law, asserting that his personal travel should be exempt from licensing regulations aimed at commercial drivers. The California court ruled that in cases of personal, non-commercial travel, there is limited grounds for mandating a driver's license, though this was narrowly tailored to Fields' specific circumstances. These cases have contributed to discussions on the scope of licensing requirements for private, non-commercial travel, with rulings that sometimes align with the viewpoint that not all private travel needs to fall under state licensing mandates. And here's a few relevant statutes and codes. Title 49, Subtitle 4, Part B, defines a commercial motor vehicle in the context of commerce. 23 CFR 1250, part of the Highway Safety Act, which primarily targets commercial motor vehicles for compliance. Title 49. Chapter 145. Section 14506. States cannot enforce identification requirements on commercial vehicles beyond DOT requirements, implying different rules for private vehicles. Fifth Amendment protects the right to liberty, which includes the freedom to travel. In essence, these cases and statutes underscore that if you're traveling privately and not engaged in commerce, you may not fall under DMV or DOT regulations designed for commercial driving. By not consenting to commercial terms, you are asserting your right to move freely without a license. Once again, this is Red Pill Awakened, here to help you reclaim your freedom of movement. If you're ready to exercise your right to travel, my $125 status correction package has everything you need to affirm your rights and navigate the system. And if you support this message and want to help spread awareness, please like, share, and leave a comment. Thanks for tuning in, and stay empowered.